Good morning. This is our Justice for Survivors webinar, and we're going to be discussing civil litigation under the TVPRA. And I am joined by Gregory Zarzar. Gregory is the founding member of and lead trial attorney at the Zarzar Law Firm based in Birmingham, Alabama. Gregory has practiced law for over 23 years and has represented crime victims in civil litigation for over a decade. He's a member of the National Crime Victim Bar Association and is believed to be the first attorney in the country to use the civil remedy provision of an anti-human trafficking law to bring a lawsuit on behalf of a sex trafficking survivor against a national hotel brand. He's also one of the first attorneys to overcome a motion to dismiss filed by the notorious website Backpage.com, who for years had used Section 230 of the Communications Decency Act to fend off lawsuits aimed at holding the website liable for its role in facilitating domestic sex trafficking. So we're excited to have you today, Gregory. Thanks for joining us.
Well, Leah, thank you for the invitation and the opportunity. I appreciate it.
Yeah, I am so happy to have you here, and I'm really excited about getting to discuss this because the civil litigations was, as we've discussed, as you and I have discussed, was not something that I understood well. And I see the way that this has the potential to create incredible impact, not only in the lives of the individual survivors that would benefit from civil litigation against those responsible in their own trafficking cases, but against kind of the culture of our society at large and those things that fuel continued trafficking. So I'm hopeful that this is going to be helpful to our attendees because, as I know we'll discuss, this only works with referrals and with survivors being in a place that they can go through these proceedings in a way that isn't harmful to themselves or where they have support. So I'm excited to get a little more information. Can you start by just catching us up to speed on the TVPRA and what civil litigation within that entails?
Yes. So obviously the TVPR, it was originally the TVPA. I will tell you that it was the Trafficking Victims Protection Act, first real law that codified and defined what human trafficking was. So in Congress, in passing the TVPA in 2000, sort of recognized for the first time and defined for the first time how trafficking works in the modern day, the more nuanced ways that individuals can be controlled by traffickers. And in doing so, originally it was just a criminal statute. So they're often the Chapter 77 crimes, and rightfully so. This is heinous conduct, and people that engage in it should be prosecuted and put away. And that is what, at least under the federal law, is the burden that rests with various law enforcement agencies and U.S. attorneys' offices throughout the country. In 2003, Congress amended or reauthorized the TVPA and it became the TVPRA. And in 2003, they added the civil remedy, which for the first time created an opportunity for a survivor of this crime to file a civil lawsuit. At that point in time, the potential defendants were relatively limited. Most obviously, the trafficker themselves could be sued under the TVPRA as it existed in 2003. But as Congress sort of recognized the enormity of the issue and the importance of kind of a comprehensive approach, I like to look at it as almost like a toolbox, that the civil remedy provision is a really important tool in addressing a more widespread attack on how trafficking operates, because it is not operating in a vacuum. What we know now from our experiences is that traffickers in large part operate out of maybe hotels. They use the Wi-Fi that is free at a hotel. They use a smartphone. They use the websites. They use Cash App and various other financial or end-to-end encryption type applications to communicate. They're not operating without the use of industries, for lack of a better word. And so in 2008, Congress reauthorized the TVPRA again, and this time expanded the civil remedy to allow a trafficking survivor to bring a lawsuit not only against the perpetrator, But anyone who knowingly financially benefited from participating in a venture, which they knew, and this is kind of the really critical piece for civil lawyers, or should have known, was in violation of the TVPRA. The should have known language is critical because as it relates to criminal prosecutions, that burden of proof is the highest one we have in our justice system here in the US. I like to use numbers. I think people typically say it's about 95% that burden in a criminal context to convict someone is as high as it gets. In a civil context, the burden of proof is just anything over 50%, a preponderance of the evidence. So a much lower burden that civil lawyers have in bringing lawsuits, and rightfully so, because you're not necessarily jeopardizing someone's liberty and putting them in prison. It is essentially, where's the preponderance of the evidence? Is the weight of the evidence in more favor that this particular industry, business, whoever it was, did they know or should they have known that they were profiting from a trafficking venture? And that really opened the door for a whole host of potential defendants that a survivor could sue and potentially lead to a really, really meaningful recovery that could lead to kind of a new and free life with, the means to get the help that is anticipated a survivor will need throughout the rest of their life.
Yeah, absolutely. Because healing is it's a costly endeavor. And I think the thing with survivors is we come from not just a place of many of us come from a place of not only having don't not having access to generational wealth. We start in like a financial deficit when we exit, right? From whether it's legal fees or fees related to debt that our trafficker put us in, or credit debt, things like that come along with it being in a survival mode or being directly related to the trafficking experience. Not only is it very difficult to pay for therapy and pay for services and things like that. So that was one of the things that I was seeing, like this could be so impactful in the lives of somebody who was trying to rebuild their life by having access to housing, not having to worry about the trigger of losing housing, which I know with a lot of the survivors that I work with is a huge trigger, right? So I could see how that would be very impactful. What are some of the requirements for a case moving forward with civil litigation?
All right. And thankfully, you just really, in order to bring a case under the civil remedy provision, which is section 1595 of the TVPRA, in order to bring a case under that provision of the TVPRA, you really just have to be a victim of the crime. Your trafficker does not have to be prosecuted. Doesn't even really have to be charged. I have represented survivors whose traffickers were never charged and successfully represented, been able to resolve claims on their behalf against businesses or industries that we alleged had violated the TVPRA's civil remedy provision. And even though their trafficker was never arrested or charged, I will tell you that actually is beneficial when there is an underlying conviction, especially when the survivor was 18 or older at the time of their trafficking. And the reason why that is rather significant is you don't necessarily have to focus as much on proving the force, fraud, or coercion element because the conviction itself helps establish that the survivor was in fact forced, defrauded, or coerced into the victimization. So, and again, with a minor, anyone under the age of 18, it is automatically trafficking if they're engaged in a commercial sex act of any kind. So in those cases, not as important, I shouldn't say important, not as helpful if there's a conviction or not, because you don't have to prove that force, fraud, or coercion that you would with an adult survivor. Going back to what you said before about sort of the cost, like we know there's been a ton of studies as it relates to the impact of child sex abuse survivors in their lifetime. On average, are going to need about $250,000 in mental health care. I got into this work because I did a lot of work on behalf of child sex abuse survivors. And I was meeting with one particular survivor who was the victim of familial abuse. and this has probably been about 15 years ago now, and learned that she didn't think it could get worse at home. And so she ran away. And then I heard the story with that within a day and a half, she was being re-victimized by a trafficker in a hotel. And even though she was well under the age of 18, she had been staying in this hotel for weeks at a time. And I thought to myself, there has to be a remedy here. And in fact, Congress had passed one. It was just a tool that was gathering dust in the toolbox. And since that time, my practice has focused, and even though I live here in Birmingham, Alabama, has been representing survivors throughout the country in litigation using the civil remedy provisions, not only of the TVPRA, but once Congress led the way with that, most states, over 45 states, have now passed similar state legislation that also has civil remedy provisions embedded within in those as well.
Yeah. And what are there's some timeline limitations there. What are those?
Thankfully, Congress sort of recognized in the beginning that survivors will need time. So the statute of limitations for an adult, someone who was an adult when they were trafficked, is 10 years. So that is relatively lengthy. I'd love for there not to be an arbitrary deadline, but it is 10 years is the statute of limitations for filing a civil claim under the TVPRA. Now, each individual state may have a different timeline for their civil remedy provision. So it is necessary that you kind of look at both potential claims. But for the sake of an audience that includes folks from across the country, I think we'll focus on the federal statute.
Yes, please.
Separately, if you were under the age of 18 at the time of your trafficking, so long as you were not the age of 28 when the law changed in 2022, there is no longer, President Biden signed a law that says there's no longer a statute of limitations applicable to survivors of sex trafficking if they were victimized under the age of 18.
Before 20, what was the age there?
September of 2022. I don't have the exact date, but it was some date in 2022 that President Biden eliminated the statute of limitations as it relates to federal claims under the TVPRA for a minor victim.
Yeah, that's awesome. What are what are the stages of walking through that civil litigation?
Yeah. So first and foremost, and this is what I try and keep in the forefront of my mind, is number one, do no harm or do as little harm as possible. So is pursuing a civil case in the best interest of the survivor at this time? And I have had cases that I thought would be really, really, really good civil liability cases, but the survivor was just not necessarily in the right place to potentially have to handle an adversarial process, which litigation by nature is, and especially when you are pursuing significant and meaningful recoveries from industries that resist the suggestion that they have profited from a trafficking venture. So that is kind of the number one thing. But once you feel like through the network of advocates that they've had and through sort of the ability to preliminarily rebuild their lives, if you feel like it is in the best interest of a survivor to consider pursuing civil claims, the important part of civil litigation is they're in control. Unlike the criminal process, where they are not a party to the case, they don't get to choose who the government's lawyer is prosecuting. They have all the control. The way the civil case works, they get to choose who their lawyer is. They get to choose who they sue. Trauma-informed lawyers can talk to them about means by which we can file for protections of identity in the case, and separately move the court to protect the other side from doing anything that could jeopardize the safety and well-being of a survivor should the trafficker not have been prosecuted or should affiliates of the trafficker still be out there. So it's all about keeping that front and center, what's in the best interest of the survivor, and then separately discussing with them who the potential defendants could be and what the potential recovery would be. Obviously, there are no guarantees associated with any case in litigation, but because the way the fees would work under the TVPRA, the defendants would be ordered to pay those fees if the plaintiff is successful. I take these cases and the expenses of these cases and file them when I think that I can win them. Like it would be an unsound business practice to put someone, number one, it would be cruel to put someone through a litigation process if you didn't think there could be a meaningful recovery and a likelihood of success. So all of that screening, the advantage of a survivor in reviewing a civil case is that they get to kind of do that with their lawyer at their own pace, so long as there's not a statute of limitations crunch.
Yeah, yeah, that makes sense. What's kind of the legal process, I guess? Like how long do these typically take? What's the process of determining whether or not that would be a case that would be eligible under the TVPRA?
Yeah, so generally the way it works is you will meet with the survivor, find out a little bit of information. If there is information about the survivor's situation, either through a prosecution or elsewhere, I try and gather as much as I can to not have to ask the survivor questions that I should be able to get the answers from another source. So this is where advocates are especially helpful in assisting a civil lawyer in getting a pretty good grasp of the facts, the length of the trafficking period, where the trafficking occurred, those types of things. There are going to be questions, unfortunately, that I do have to ask of every survivor that may not have been front and center on an advocate's mind when they were meeting with them, or on a law enforcement official's mind when they were meeting with them, that would influence who the potential defendants could be. So that process can take, a couple of months to sort of complete the evaluation period and say, here's what I think the potential defendants could be. This is why I think this is a good case or not a good case to pursue at this time. Separate and apart from that, because of the experience that I've had in the past now, you're seeing a lot of the same opponents, for lack of a better word, defendants on the other side. So nowadays, there is an opportunity potentially to settle a civil claim before a lawsuit is even filed. So it may not be necessary to even file a case if you've done a decent enough job of gathering the information and the evidence to suggest to the other side that they need to consider resolving this case before it is even filed. And that is something that, again, you talk to the survivor about, because even though the value of the case at the courthouse steps may be greater than it is at a pre-suit stage, the potential invasion of privacy and heartache and re-traumatization that the litigation process itself could involve, there's some value in avoiding that as well. So you really want to defer to the survivor as to what makes sense for that particular survivor
Yeah,
and let that direct the litigation, as opposed to just filing the lawsuit right away and getting into the invasive discovery process. So once a lawsuit is filed, the other side typically in these cases has two options. Once they're served, they can either file an answer and the discovery process begins, or they file a motion to dismiss, saying this case shouldn't even really get off the ground because we don't think under the law it can be brought this way. And there are certain defendants, I think you early on referenced Backpage, that avoided a lot of these lawsuits in the beginning under an immunity provision through the Communications Decency Act. Thankfully, that we have been able to bring successfully lawsuits that have defeated motions to dismiss against various websites that either have hosted CSAM or other trafficking content. And so, there are ways to overcome some of the defenses that may be coming in the early stages. And then once you get into discovery, you really are figuring out what did this particular defendant know about what was happening either on their website or on their property or the transactions through their bank or financial institutions to evaluate the level of liability.
Yeah. How long does that usually take? What's the overall length?
Yeah, so obviously some courts move faster than other courts. And to say that, so obviously it can settle at any point in time. So a case can settle before it's even filed. It can settle within a month of it being filed. But if you were to see a case from filing of a lawsuit to a trial, I think the fairest assessment in the federal court would be somewhere between 18 and 24 months would be the time period you would be looking at generally, typically. There are outliers back and forth because you never know what issue may get appealed in the interim that is allowed to be appealed. So there are things that can happen along the way to lengthen that time, that general timeline.
Yeah. And you kind of touched on this a little bit, but I wonder if you have any more thoughts on the importance of collaboration with nonprofits and advocates during this process.
Well, I cannot emphasize the critical importance of that enough today. And why I say that is because I almost look at what a civil lawyer can do as someone who is not on the front lines of a battle at all. Like the advocates, the victim advocates, the prosecutors, they are on the front line. When someone is absolutely in a dire situation and has no stability, they are that initial front line to attack this issue. Where it can benefit a civil lawyer, number one, and number two, an advocate who really wants to do their job in a way that looks for complete justice. And that's how I try and talk about it, like full justice. Like clearly, the criminal side is just one side of the coin. Full justice, where there's a focus on the victim, the survivor, is also evaluating the civil claims. And um, that, I think, necessarily requires that there be a trauma-informed approach. This is not a car wreck. This is not a slip and fall. Even though the litigation process is filing a lawsuit, plaintiff versus defendant, the manner in which these cases need to be handled is completely different from a traditional injury case, in my opinion. And therefore, an advocate having knowledge of the importance that a survivor find a lawyer, number one, with experience in handling these rather complex and sophisticated cases, but more importantly, handling or paying attention to is probably the better word to the potential emotional and psychological impact that the litigation process could have. Because what you do necessarily give up in pursuing litigation is a little bit of privacy. The other side has a right to subpoena information. They may get medical records. They may get the ability to depose people that are in your life to confirm some of the positions that you take that is the result that you say are a result of the trafficking. So there are disruptions naturally that occur as part of the litigation process. And so you just want to make sure that that particular survivor is meeting with and working with a lawyer that has experience and works in a trauma-informed manner.
Yeah. And let's go off script a little bit and back up a little because I'm seeing a couple of things in the chat that are following kind of the similar vein because we have such a diverse group of people in the chat. We have some people who are retired lawyers, I see in the chat. We also have people who have been advocates or survivor leaders who don't have as much of a grasp on the legal system and need some more clarity. Can you explain really what the difference is between civil and criminal and how they may overlap and may stay completely separate with a big wall between and why they might be related and why they would be completely unrelated?
Yeah, totally. I probably should have done that from the beginning, and I appreciate the questions because that is an excellent question. So obviously, as I mentioned before, originally this is in the United States Code, it's under the criminal section. And so it is a crime. The law enforcement investigates crime and prosecutors, U.S. attorneys' offices prosecute the criminals uh, in an expectation, hopefully, to lock them up for committing such a heinous act. The civil side of things is really just a different side of the coin. It is, hey, if you are a victim of this crime, we are embedding into this criminal law a civil remedy where you can go find your own lawyer who can sue anyone who violated this trafficking law. So you can seek civil remedies. You can seek monetary damages for, future lost wages, future medical expenses. And what is covered in civil cases that can't be covered in any way in a criminal context are emotional damages, pain and suffering, the pain and suffering associated with having been trafficked, and the permanency of the emotional harm from being a survivor of trafficking.
Right.
And that is something that there is no yardstick for how a jury will value that. Only the experience of having litigated these cases that I trust that most juries recognize the endless amount of trauma associated with having gone through a trafficking situation. So,
And
uh,
one doesn't necessarily lead into the other, is the other thing that I think is important. Just because there's been a criminal case doesn't automatically create a civil case. It's something that you would then need to go and get a civil lawyer and have them file on your behalf and opposite as well. Just because there has been a civil case and someone's been held responsible in civil litigation does not mean they will be held responsible and prosecute in criminal litigation, they were even if they were held liable.
right,
Under,
right. So, yeah, that is a very important point. I know I mentioned earlier there doesn't even have to be an arrest for there to
right,
be an evaluation and a pursuit of civil remedies. And separately, because of that burden of proof I talked about before, even if someone is charged with trafficking criminally and may be found not guilty, doesn't mean you still can't later bring a civil case because the burden is lower. It could
right,
have been like the jury got hung up at like with a reasonable doubt that had them at like the 85% level, even though most of the evidence was in the survivor's favor. You could still bring a civil claim. Obviously, the most classic example in my lifetime, and I'm dating myself a little bit, would be the fact that O.J. Simpson was found not guilty in the criminal courts, but found liable for the wrongful deaths of Nicole Brown Simpson and Ron Goldman in the civil courts.
right.
That's just an easy way to illustrate that
Yes,
while they involve a lot of the same evidence sometimes, they're completely distinct court cases. But the reverse is really helpful. If there is a conviction, because the burden is higher in the criminal case, that carries a lot of weight in the lower burden civil case too. So it is, again, I go back to that where there is a conviction, that is obviously a really helpful thing as well.
absolutely. We have gotten so many questions in the chat, and I think to me that shows that this, as you and I had discussed in previous conversations, that this is something that is not being talked about, that people are not having conversations like this around. And so I do want to get time to get into a lot of these. And some of them are case specific, which if they're case specific, I probably am not going to bring up like your specific trauma history on the webinar, but I'm happy to maybe forward them along, and maybe Gregory could follow up via email with some of those things. But before we get into those, can you give some examples? What are some ways this has played out? What are some of the types of defendants or liable parties that you've been able to bring charges against or bring litigation against?
Yeah. So like we've talked about before, early on, a lot of the cases that we filed were against the notorious Backpage.com. And after several of these cases survived the motion to dismiss period, the government acted, shut them down. And so that doesn't mean obviously trafficking online has ended. So other sites have popped up. So websites are one example of defendants that we have sued under the TVPRA. Hotels, motels, financial institutions. There are a lot of regulations that govern financial institutions, which should send up red flags as to when there are questionable transactions given the numerosity, cash, whatever they may be. Similarly, we all know the classic red flags that we believe that hotels should be mindful of, knowing that this is a preferred venue for traffickers to operate out of because of the Wi-Fi, because of the supposed anonymity that renting a hotel room they believe should provide them. Thankfully, as a result of, and I don't think anyone should feel bad about not knowing about this. What I have spent the last decade doing is talking to lawyers about the fact that you can file civil cases for human trafficking survivors. Most lawyers did not know or appreciate that that was even an option. And so, and I still think you could probably use that most figure today. We've done a lot of work educating lawyers over the last 5, 6, 7, 8 years. And I will tell you, as a result of some of that work, a lot of lawsuits were filed in 2019 against hotels. Uh, I can't tell you that these two things are connected, but do you know what the hotel industry did in 2020, soon after a lot of those lawsuits were filed? They all of a sudden created a no room for trafficking mandatory training program for most branded hotels. Now, in my lifetime, civil lawsuits have changed things dramatically. And so I would like to think that some of the efforts that industries have been making of late to actually address the trafficking that may be occurring or enabled or facilitated through their businesses are now finally being addressed because they can't afford not to make changes. That is the importance of so like, obviously getting a meaningful recovery for the survivors at the top of the list. Number two would be letting these industries, setting an example, letting them know if they don't make changes, they're not going to be able to afford to stay in business. So we have a case right now pending against Pornhub for the CSAM imagery that we alleged was on their site. And obviously, since then, since the filing of that lawsuit, there's been a lot of changes into how that website functions. And it is, but truck stops, I hate to even call them this, but gentlemen's clubs, anywhere where, we're seeing it in these long-term rentals or Airbnbs, VRBOs, now that the hotels maybe are paying a little bit more attention, are traffickers trying to navigate into other spaces? There was even a trafficking survivor who successfully brought a claim or against Uber, who Uber was being used to facilitate the trafficking operation. So it really is kind of a detail intensive analysis as to who potentially could be a defendant. But thankfully, with the way the should have known language and the broadening of the civil remedy provision, there are very meaningful recoveries for a lot of the survivors we've been able to represent.
Awesome. I'm going to jump into some of the questions
Yeah.
because we have quite a few of them. And there's been a few people that have asked, and so I just kind of want to get this moving. Have you seen or have you heard of any kind of retaliation when people bring charges against these kind of bigger entities? Because they're not bringing charges against this like individual exploiter, right? It's usually these larger responsible parties that facilitated. Have you
Yeah.
seen any sort of retaliation there?
Here is the good and bad on taking on some of these larger entities. They are able to hire some of the biggest and largest law firms in the world to defend them. And obviously, those lawyers in large part have ascended into those firms and to have the clients that they have because they're good at what they do, number one. And number two, we're all governed by rules of professional conduct. and rules of court. Like lawyers can lose their licenses if they don't abide by sort of court orders or the rules of professional conduct. And, in large part, the lawyers that I have dealt with in these cases have been mindful of the survivor's situation. But it doesn't mean they don't really work hard for their clients too. So within those rules, they are going to do things, whether it's dig into someone's social media history, so like there are going to be very invasive parts of litigation that I think sometimes go a little too far, but those are debates you take to a court for a court to resolve as to whether or not the scope of what someone is doing in the discovery process is necessary for the claim. And so, there are thankfully guardrails in place so that the litigation process, while taxing and invasive, is one that, at least as to the lawyers engaged in it, that they have to be cordial and respectful of the process and the rules.
Retaliation in maybe a legal or emotional sense, but not necessarily in like a life risk type of
Right.
sense.
Not, knock on wood. Like obviously, I have thankfully not come across lawyers that are, for no reason or little meaningful reason, approaching a trafficker or an affiliate of a trafficker when you can establish what you need to establish through other means, whether it is. And again, and this is why I think while the statute of limitations being as long as it is great, it is obviously really helpful if a survivor meets with a lawyer as soon as they can assist, as
Yeah.
soon as they're in a stable
Yeah.
enough place, because there can be evidence lost in the interim. Uh,
Yeah.
Geolocation evidence, like I was definitely at this hotel for this period of time, surveillance video. There's a lot of things that can get lost with the passage of time that would help build a stronger civil case.
Yeah. Thank you. And I also see a lot of questions in the chat around things around trauma-informed lawyering. We did, myself and a couple of other people did a trauma-informed lawyering webinar. That's how I got to know Gregory, was someone referred to me from that webinar, and that is on our website. You can see all of those. We have past webinars about trauma-informed lawyering, about service provision, services for minors, services for adults, services for specific demographics of survivors, and everything kind of in between. Those are on our website at safehouseproject.org/webinars. So please use those. Those are a free resource for you. We actually have someone in the chat. She's asked quite a few questions. Who is a lawyer in Alabama, and I believe she works in one of or with clients at one of our partner programs. I'm guessing she's asking. One of her questions was if the cases are filed in state or federal court, and I know that varies.
Yeah, it varies. So for the purposes of our sort of nationwide discussion, I've focused a lot on the TVPRA. There are, like I said, most states have a civil remedy provision that you could file in state court. And there have been a lot of cases filed in state court. Some of my earlier cases were filed against Backpage were filed in state court. And under the Alabama trafficking statute back then. And so all that to say is that is going to be a case-by-case decision as well. I will tell you that the way federal courts work, it's almost like if you have a puzzle, like various circuits throughout the country. And those various circuits are now dealing with a number of these TVPR cases. And so you have to evaluate how a particular circuit is interpreting the civil remedy liability provisions of the TVPRA to see whether it makes sense to bring that case in that particular circuit or look back at the state law there. Generally speaking, not always, statute of limitations will be likely shorter in the state law. So a lot of survivors that I've met with throughout the country, maybe state law claims were already time barred because of the statute of limitations. And so you may be just limited to the federal claims. I think it's real important for me to also point out, as it relates to minor trafficking victims, the TVPRA has been looped in with another law that was typically, and I hate that the law calls it child pornography. We call it CSAM in our cases, but that's the way the law calls it. But they have combined a law that says if you are a minor trafficking victim, you can also have a claim under what is 2255, Section 2255, where they say you can elect to prove your actual damages, or you can just say, rather than even having to go through talking about the harm to me or talking about the care I'm going to need in the future, you get a flat $150,000 statutory liquidated damages award. Plus, you can still pursue punitive damages against the defendants and seek your attorney's fees as well. So, that provision I think is very important that Congress put a liquidated damages provision for child survivors because they can avoid a lot of the questions that a lawyer can say, I need to ask these questions or I need to subpoena these medical records because they're saying, look, we're not trying to even prove our actual damages. We have selected into the statutory award as it relates to my actual damage portion of the recovery. So,
Yeah, that's really important. Thank you. And gosh, there was another question. Okay, around the timelines. I've seen some questions around timelines. Does the timeline change if, oh, I guess what is the timeline exactly as far as that 10 years, right? So if the person, is it like from the last time that they experienced exploitation? What if there was like a case that was prosecuted years later, or what if there were other crimes that were related? Does that change at all?
and it can from court to court. So that's one of those issues I was saying. Various circuits are interpreting things currently. As a safeguard, I generally look at 10 years from, so if like, I'll just, pick a random hotel right now. I'll just pick a couple. Like I say, it's a Motel 6 or a Best Western. All right. Let's say the trafficking occurred at the Motel 6 in 2016 and the trafficking occurred at the Best Western in 2018. To be on the safe side, I would be looking at 2026 as the deadline for bringing a claim against the 2016 trafficking period and 2018 as the statute of limitations for the 2018 trafficking. And again, no statute of limitations if the survivor was under 18 at the age of the trafficking, so long as they were not already 28 years old when the
By
law changed in 2022. Yeah.
2022. Yeah. So our minors that we're working with now, I mean, it's hard, it's hard for a lot of us who maybe might be out already, but I think of like so many of the minors that I'm working with now that 10 years from now, when I'm looking at like all of these things, okay, here's another question that I'm seeing in there. So when I'm working with someone right now, let's say I'm working with a 15-year-old and I'm knowing she's in that hotel, okay, she's there and she's not in a place, obviously, as a 15-year-old to be recording the people that might have been responsible. As an advocate that's working for her, knowing that 10, 15, 20 years from now, she would still be eligible, what should I be doing as her advocate to just continue to make that an option for her as far as like knowing that that evidence or those signs go away?
Well, document would be my suggestion because as we know, and as I have experienced that survivors, because I think it is part of surviving, naturally may sometimes suppress information that they knew or experienced at one time, undoubtedly, but for whatever reason, um, are unable to recall it either in a deposition. So, like that documentation can be very helpful if I'm meeting with someone who right now is 29, but they were under the age of 18. So, like, they're still within statute because the law had changed well before they reached the age of 28. And if someone has documented really well, that can really help refresh recollection of events and assist a lawyer who may ultimately rely on the advocate as a witness in the civil claim if it goes to a trial to help establish some of the necessary information relative to the trafficking.
Yeah. And what and I know this varies, but what is the range of these damages that you're tending to recover?
Yeah. So obviously it does vary, but again, I do not, they can be expensive to prosecute. So I am not looking to litigate against some of the largest corporations in the world without looking for a really significant recovery. And so, you know, I can say that I have received letters that, I have a home for the first time. I've been able to buy a home for the first time. I've been able to do this. I don't have to worry about my bills or, there are things that, you know, can be life altering as far as the value of these cases, to speak in very general terms. Now, there are some hotels that are not adequately insured, or there are some, you know, claims that are not as strong as others. And so you just have to kind of evaluate as you're going along. And there are some survivors, and this I think happens to every lawyer, that as you get into the litigation, there could be a situation where the survivor says, I know I thought I was ready to go through this process all the way, but my perspective is different now. Let's see what we can get this case resolved for. You just have to kind of, advise as best you can, but at the same time, do more listening. I think God gave us 2 ears and one mouth for a reason in these cases, for sure.
Yeah, yeah. Looking at some more of the questions here. Okay, this is above my pay grade. This is lawyer talk, so I'm going to ask it to you exactly as it's written. Can you talk a little more specifically about how you've overcome immunity provisions like those in the CDA 230, and perhaps how you overcome arbitration agreements or work within arbitration frameworks if these larger companies require that in their terms of use?
Yeah, so under the CDA, early on, before FOSTA sort of entered the equation, a lot of the arguments stemmed around content creation. So, like, a content creator was not immune from liability under the CDA and never has been. So, that is one way that we argued early on that websites, through the creation of their algorithm, through creating categories or tags or titles or modifying titles or the metadata or the way they optimize results, they were content creating themselves. And so, I think one of the classic arguments made a long time ago was you could have an ad that says, even though all of the wording came from someone else, their editing or their processes for creating ads changed the message. Let's say an ad was taken out that said, not working $10. Um, if the editing process took out the word not, and it says TV working $10, it is completely different message, completely different. Even though they didn't, arguably add words, they only took out words. The way that messaging changed, the argument could be made, you're getting into content creation when you start to do things that affect the way a message is received. Similarly, on the arbitration issue, like at first, rule number one, like, if someone is trying to enforce an arbitration agreement that was entered while someone was being trafficking, you can clearly make the argument that there was duress involved. And so the agreement in and of itself is unenforceable because the person was not in a position where they could freely and voluntarily consent to anything. So that would be the first argument that I think you would make. And number two, and this is an argument we make in the CDA context and elsewhere, that no one can lose due process rights or immunize criminal conduct. So, like, as it relates to the CSAM that may be on a certain website, the position is the Congress is not going to pass some law that says, hey, you can be forgiven for doing something that is criminal by nature. That's not really the purpose of the CDA.
Thank you. And I'm just going to combine kind of one more question, and then we're going to start to wrap up. But what about it as far as potential, I don't know what you would call them, defendants. I don't know if they would be called that in civil litigation, but would like govern our does it have to be like private entities, like private businesses or citizens, or can it also be things like child protective services, a state, other kinds of more governmental?
Yeah. No, and they are called defendants. That is the one similarity between the criminal process and the civil process, is they're both called defendants. The people, what I call on the bottom side of the V of the lawsuit. So in the criminal context, it's either going to be the state of California, the state of Alabama versus so and so, or the United States of America versus so and so. And in the civil context, the defendants are called defendants in both situations.
So
So yes, so those entities can be defendants. I will tell you, when you get into government entities, you introduce yet more complexities as it relates to the potential legal defenses because of immunity provisions that may be afforded to certain state actors or to states generally. And so that is going to be, a case by case, state by state analysis that would need to occur, and whether or not you can sue the protective services or the employee individually working for the protective services who may have insurance through that job as well. So there, that really is kind of a individualized analysis. But yes, those types of entities are entities that are sued and can be sued, but it really depends on where you're talking about, what the circumstances were.
we've seen that like with like people who have been victims of like let's say police brutality, right? Suing police departments or things like that, right? That would be kind of a similar example.
Yeah, that there are means by which, if it's a constitutional violation, at least under 1983 for those police brutality cases, but in our context, a little bit different analysis, but an analysis that needs to be done regardless if a state agency or government entity has at glance and review potential liability under a trafficking law.
And I see, oh, I think I'm kind of freezing a little bit. I see there's still some confusion over the age limitations. So let me say it back and see if you need to correct me. If somebody was under the age of 18 when they were being trafficked, these and they would be less than 28 in September of 2022. There is no statute of limitations there. But if somebody was under the age of 18, but they were more than 28 by that time, the statute would be 10 years. And if someone was over the age of 18, the statute would be 10 years from the last time they were exploited
Yeah.
at.
So the best way to kind of explain it, and again, I wouldn't swear to the September date in my mind. That's what it is, sometime in 2022. But the way the law was originally written, there's a 10-year statute of limitation. So if you were 22 at the time of the trafficking, you have until 10 years later.
You were 15.
If you were 15, you had 10 years after you reached the age of 18. So it didn't start, your 10 years didn't start to click under the TVPRA until you reach the age of 18, which is why when the Congress did away with, for minor victims, the statute of limitations, it was only if your statute hadn't already gone. So that's why the age 28 came into place. So when you reach the age of
Because that
18,
was less than 10
yeah.
years.
So once that was removed, anyone who had not attained the age of 28 by that date, and they were a minor victim, there's no longer. So like a minor right now, or even someone who is 29 or 30 years old right now, but was a minor when they were trafficked, there is no statute of limitations applicable.
Awesome. Thank you so much for clarifying that. Well, we're starting to wrap up. Do you have anything you want to add before we close?
No, I would emphasize again my appreciation to you, Aaliyah, and to Safe House Project, and to everyone on this call, because being here is a very clear sign that, number one, you guys are all experienced at what you do already for survivors, and you're just trying to expand your information base so that you can maybe figure out another way, a new and novel way to help out a survivor, either that you've helped in the past, or that you're currently helping, or that you will help in the future. And so this is really all about gathering information so that as you are helping the people that you encounter through your work, that you can tell them, that maybe they need to talk with a lawyer about potential civil claims, because what we do know is that the civil remedy provision will change industries and change lives, more importantly, because you can potentially provide for a very meaningful recovery, which can eliminate some of the normal life stressors that everyone has to deal with. But I really want to emphasize the importance of making sure that this crime is understood, but it is also understood that the crime has the potential for that full justice component that I talked about, the other side of the coin.
Yeah, absolutely. Well, thank you again for being able to come on and inform us and take our
Yeah.
questions and teach us more about this. And I'm really hopeful that more survivors are going to be able to access just some more meaningful recovery and some more opportunity for like following their own dreams and things that seem unattainable because of finances, and then really change those industries as well. Because I've seen, places like Motel 6 even, right? Huge changes in the way they conduct business. And I believe that it would be certainly because of kind of the knowledge base that comes with what's available out there. So thank you so much again.
No, and I really appreciate it. And again, I'm happy to answer any specific questions anyone's got. Obviously, if they reach out to
Yeah.
Aaliyah, or they can, be found online if
Yep.
it's easier to reach out directly to me. Either way. Lastly, I know I sort of danced around some of the discussion about value of these cases. There are certain reported returns that I'm happy to talk about. Like for 3 survivors, there was a $24 million recovery. So like we're talking about very significant sums of money potentially for survivors that, number one, can help them sort of have a new and free life, but number two, incentivize industries that are being used to facilitate trafficking to change their ways.
Absolutely. Thank you so much to everyone for coming. And thank you, Gregory, for sharing your expertise and your time.
Thanks to everyone. Thank you.